My name is Simon Cook. I'm a partner at Sullivan and Worcester UK LLP and also a member of the Executive Board of the International Trade and Forfaiting Association, ITFA. And I'm here to talk to you a little bit about the industry rules that apply to certain types of trade finance instruments, such as demand guarantees, letters of credit, standby letters of credit, and prom notes, bills of exchange. I think the ICC rules that we have cover three of those documents. The UCP 600, as it's known colloquially, covers documentary letters of credit and is very much designed with them in mind. You do sometimes see those rules applied to standby letters of credit, even though they weren't designed for that purpose, but there is enough of an overlap that those rules still make sense when applied to standby letters of credit. But standbys do also have their own set of ICC rules, which are particularly designed to apply to those types of instruments, which is colloquially the ISP 98 rules. Because documentary letters of credit are the intended means of payment and standby letters of credit are only a fallback if there's a non-payment, there are certain rules in ISP 98 which would not make sense in the context of documentary letters of credit, which is why those rules only apply in reality to SBLCs. The third set of rules are the URDG 758 rules, which apply to demand guarantees. Now, all three sets of rules that I've been talking about cover very similar sorts of issues and have similar principles. So they have that principle of irrevocability, unconditionality. They deal with things like how and when documents have to be examined, what sort of timeframes you have for payments, what rejection rights an issuing bank or a confirming bank may have. They also look at how you might deal with amendments and also assignment and transferability. Now, they don't all deal with these topics in the same way. You certainly can't have a one-size-fits-all, for example. One relatively recent difference is the way that they each dealt with the pandemic and what would happen when you aren't able to present documentation because of the restrictions. They all dealt with it in a slightly different way. And the best way to understand them is really to read them. It's not possible to do a complete comparison for the purposes of this discussion. The industry rules are not the only thing that apply. There's also the applicable law. Query whether you have an express governing law for letters of credit, standby letters of credit, demand guarantees. You certainly can and frequently do, although equally it's common not to have one because the parties don't wish to have the argument over what governing law to choose at the outset and prefer to rely on the fact that actually everything will run smoothly and they'll never have to have that discussion. But if they do ever have to have the discussion because something goes wrong, that can be a painfully long and costly process and with an element of uncertainty as to what the ultimate answer will be. If you don't have a governing law, URDG 758 in the context of demand guarantees does actually set out certain principles for how you ought to determine the governing law if you do need to apply it, but UCP 600 and ISP 98 don't have that type of provision included. In terms of assignability and transferability, all three sets of rules deal with this with some overlap. There is a blanket ban on transfers unless the instrument itself expressly says that it's permissible. But the rules take different approaches as to what additional requirements there may be to achieve the relevant transfer. All three allow, in any event, assignment of proceeds, if not necessarily a transfer of all of the other rights under the instrument itself. But even on that, they differ amongst themselves. And it is very important to familiarize yourselves with each of the sets of rules on these points as they, whilst overlapping in some respects, are in fact different in other respects. The instruments that I've not talked about are bills of exchange and prom notes. There aren't any ICC rules that apply to those, but there is a discussion ongoing at the moment around governing law and whether or not you can have an express governing law or whether the Bills of Exchange Act of 1882 precludes that. There are two schools of thought, but in any event, there is a current consultation process ongoing to rectify the position or and clarify the position so that it becomes clear that an express governing law will be possible in certain circumstances and the consultation is really around the scope of the individual contracts that make up the overall bill of exchange layer of contracts can apply. It may only apply to the original parties and the current holder. It may apply more widely depending on where the consultation process comes out.